Welcome to Case in Point, produced by the University of Pennsylvania Law School. I'm your host, Randy Garnick. In this episode, we'll examine the high-profile case and conviction of Adnan Syed, brought to the world's attention through the popular Serial podcast. We'll explore how his case and conviction informs us about and reflects the fair administration of our criminal justice system. We're joined today by one of the featured participants in Syed's case and on the Serial podcast, Rabia Chaudhry. Robbie is an attorney as well as a National Security Fellow at New America and the president of the Safe Nation Collaborative. Also with us is John Holloway, Executive Director of the Quattrone Center for the Fair Administration of Justice here at Penn Law. He's also the author of the book, Killing Time, an 18-year odyssey from death row to freedom. Thank you both for joining us. Rabia, first, please give us some brief background on Syed's case, and then please tell how and why you became involved with the Serial podcast.
Adnan Syed was arrested in 1999 for the murder of his class fellow Heyman Lee and his ex-girlfriend. He was 17 at the time, she was 18 at the time. She had left school on January 13th, 1999, and she was never seen again. About 6 weeks later, her body was found, and shortly thereafter, I think like 3 or 4 weeks later, he was arrested for the murder. He's always maintained his innocence, and I know Adnan because he is like a little brother to me. He was my younger brother's best friend. He still is. And I've known him since he was about 13. And we also lived in kind of the same tight-knit Muslim community in the Baltimore area. Our parents still live in the same neighborhood, in fact, as his. So I was in law school at the time, and I wasn't directly involved in his case during the trial. He was tried a year later, and he was convicted, and he was sentenced to life plus 30 years. He was a juvenile, he had no criminal record. Even at his sentencing, he maintained his innocence. And, through the direct appeals, through the post-conviction appeals, I've been kind of there with the family as an advocate and supporter. And he's essentially lost all the appeals so far. In terms of Serial, shortly after the post-conviction hearing, which was in the fall of 2013, I got the sense that we're gonna lose the post-conviction. And I thought it's time to go to media because journalists, investigative reporters can do things that lawyers can't do. They can do things that people close to, the parties can't do. I certainly wasn't going to be knocking on doors and talking to witnesses because, that can really taint things. So I contacted just not quite randomly, but Sarah Koenig from This American Life because she had written a story about Adnan's attorney back in 1999. And this is an attorney who was kind of notorious in the Baltimore legal community. She had done a lot of unethical things with a lot of different client cases. She had broken the record for attorney complaints, and then she was disbarred, and then she passed away. So Sarah had written about Gutierrezz a long time ago. I reached out to her. Within a week we met, and within a few weeks she kind of committed herself to the story. She was interested because she felt like things were not quite right in his case.
Thank you for that. John, can you talk a bit about what the Quattrone Center does, what its mission is, and through that framework, what is your take on this case?
Sure. The Quattrone Center was founded about 18 months ago, and our mission is to work with the criminal justice system, practitioners throughout that system, and try to reduce errors that occur in the criminal justice system. And the way we do that is we take what we call a systems approach. So if you think about litigation and the appeals process as a case-by-case or individual-by-individual approach, what we try to do is take a step back and look at criminal justice as a system and as an aggregated set of interactions throughout individual courts that involve prosecutors, police, defense attorneys, judges, and juries, and to identify areas that where those interactions are leading to unintended consequences of one sort or another, because you could view an error in the criminal justice system as a wrongful conviction, which is really what we're talking about in the Syed case. Do we have a wrongful conviction? You could also think about it as the failure to get the right person. And so each of those is an unintended consequence of the system, because there's no question that a young woman was killed here. And we want to make sure that we handle that appropriately and that we get the right guy in the right way. And so we take principles from other complex systems like healthcare or aviation and try to bring them over to criminal justice to help all parts of the system do their roles better.
And your take on the case, John?
Well, I think in the first place, it was a fascinating podcast and story, and really riveting. And in my mind, I think that what the podcast did really well is it made clear how difficult it is to know the truth. I think Adnan clearly, as Rabia said, maintained his innocence throughout, and that's a very compelling feature, particularly when you realize that the evidence as portrayed in the podcast is really very far from cut and dried. And in a situation where we really want to be beyond a reasonable doubt, I think it's very hard to look at all of the information that was put out in that podcast and feel comfortable that we've done that in this case. The other thing that I think comes through in this is how difficult it is to reverse a decision once we've made a decision that's final. The jury is the trier in fact, and when when a jury has made a decision, it's very, very difficult for appeals courts to evaluate those facts. And it's just a very complex legal challenge that Adnan has in a case where I think no matter what your view is, I didn't see anybody who thinks this is absolutely rock solid. And so it's a real concern when you see a case like this that where guilt is far from assured, and yet we've put a young man in prison for life plus 30 years.
Rabia, of course you believe Syed is innocent, but what are some of your key concerns about the case, particularly including his representation?
I mean, I think, I'll address that, but let me just also pick up where John left off, which is, he talked about what Serial presented in terms of the case against Adnan. And for people who stopped, following the case after Serial, a lot happened after Serial. A lot more evidence came forward that made the case even more shaky. Serial was a great narrative, but it wasn't in terms of like a deep investigation. It really wasn't a deep investigation. I think Sarah did a tremendous job, and we're always going to be grateful to her, because nobody could ever. This level of global attention and media attention and publicity, like nobody could ever imagine that. And I think it's been very helpful for our case. Having said that, though, there were many, many things that the Serial team missed, and his lawyers have missed over the years, And we have a lawyer, Susan Simpson, who's been investigating and blogging the case independently, completely, since the show started. And she now is kind of directing our private investigator. We've asked her to do that because she really is incredibly sharp, and she's discovered all kinds of things in the existing documents that nobody really realized before. So, and all of these things, again, point to major issues with the case. Shortly after Serial ended, Jay Wiles, who was the main witness, gave an interview at The Intercept in which he completely undermined his testimony in court. He said, "I lied under oath. The timeline that I portrayed," that timeline was extremely important to the case because that timeline was matched up to these phone records very, carefully by the prosecutor. He completely undermined that timeline. In addition, 1999, this was the first time such cell phone evidence was ever used in Maryland, ever. Dozens of cell phone experts in the last 6 months have come forward to us saying that was used completely wrong. The conclusions the state drew from that and used to convict Adnan, saying he was here, he was here, he was here, was completely off base. Her medical reports were not, Gutierrezs, Christina Gutierrezz, who was his attorney, she dropped so many balls, I don't even know where to start. She didn't hire a single expert in this case. She was paid to hire experts. She didn't hire a forensic expert, a medical expert, a cell phone technology expert. She didn't account for his time at all. She was given letters written by a potential alibi witness. Now, whether or not that witness would have stood up under scrutiny remained to be seen, but at a minimum, her duty was to contact that witness, and she never contacted that witness. And that witness, in fact, potentially could have led to a couple other witnesses, because she said, "I was with him, and my boyfriend and his friend also saw him there at the library." And there were many other people. There were people in the community who said, "We saw Adnan that night in the mosque." And this is around the time that apparently, the witnesses alleging that this young girl was buried after she had been killed. One of those witnesses testified in the grand jury trial. He testified to this fact. And Christina Gutierrezz never called him, to testify. The state's case lasted about 6 weeks, and her defense lasted from Thursday to Friday. And they rested, and he was convicted in 2 hours. So, And also I think the police did not investigate fully. There were a lot of things they didn't look into. The young man who was a state's witness. I mean, first of all, we have to remember there was absolutely no physical evidence tying Adnan to the case, to the murder. They tore up Adnan's house. They took his clothing. They took his shoes. They took his car. Nothing, not soil samples, nothing matched. They found a couple of fibers and a hair on the body that did not match Adnan. All they had was this young man's testimony, which was given in exchange for a really great plea deal. And this is a young man who himself ties himself to the crime, saying that I got rid of my shoes, I got rid of my clothes, the instruments to bury her came from my home. The police never even pulled his phone records or his pager records or searched his home, you know? And throughout the day, he had Adnan's car and cell phone because Adnan was in class. And there were people that he called around the time that Heyman disappeared, that Jay Wiles called using Adnan's phone. There's no information that the police ever contacted those people. Like, why wouldn't you have, in the records? Why wouldn't you have any, interviews with those potential witnesses who would have been talking to Jay Wiles around the time that this girl disappeared? So, and then you have the prosecutor. I mean, like, every party botched this in many ways, and that's my real issue is that if any single one of these parties had done their job right, we would not have seen the same result. I really feel that way.
And what is the status of the case right now, Rabia?
So we had lost the post-conviction in January 2014, a little over a year ago. And when you do that, you have the right to petition to get another chance at post-conviction, essentially, and it's very rarely granted. So that petition was filed almost immediately last January, and since that time, Serial happened. Serial happened, and a lot of other things happened. And the Baltimore legal community is paying attention. What we understand is the Attorney General's office is paying attention. The judges are listening. They're reading these things. The prosecutor from that time, Kevin Urich, has come out and made a few odd statements, and I think that's brought even more attention. So, and essentially, in February, it was granted. That petition for a new post-conviction was granted. It was granted within 3 days of our last filing, which is like unheard of. It takes over a year usually to get some kind of response from the court. I feel strongly it's just the public scrutiny, and it's like also there's allegations that the prosecutor lied under oath during the post-conviction hearing that really is compelling the court to do this quickly, and they're taking a serious interest in it. So we recently this week just filed his brief in support of the post-conviction, and the hearing is in early June. So it's a very fast docket too.
So that's the next step, the hearing in
Yep,
June.
the hearing in June.
And I'm going to turn to you, John. You champion something called root cause analysis in criminal justice. Could you please explain what this is and how this may be applied in Syed's case?
Sure. Root cause analysis is a process that's been used in places like healthcare and aviation and other industries to make sure that event reviews are happening when it's a cycle of when an error in a system is identified, looking back to figure out not just the close contributing factors, but maybe deeper issues that might be embedded in a system to ensure that when you implement changes to eliminate an error, you're actually implementing useful changes that get right down to the core factors within your system that have caused that error. And it's a process that involves the collaborative review with everybody who is involved in a case. If you think about it, the National Transportation Safety Board uses root cause analysis to do investigations of train derailments or plane crashes. And what they'll do is they'll get a multidisciplinary group of experts to come in, do detailed interviews of all of the participants in the flight, not to identify who's to blame, but to understand really what happened and what the sequence of events was that led to it and why, in each instance, the person involved did what they did and kind of what they saw at the time. So it's a way of evaluating the real-time decision-making so that we can really identify areas where those decision-making trees took us off in a direction we didn't want to end up in. And so the Quattrone Center has used root cause analysis with a number of different stakeholders in the criminal justice system to evaluate errors and try to track back to the implementation of policies that would prevent those errors from happening in the future. I think Rabia has identified in Adnan's case a number of things that we see coming up again and again and again in exonerations. So over the course of the past 25 years or so, We've now identified close to 1,600 cases where we know we convicted somebody who is innocent. And they're now actually increasing. We're discovering more and more of them as we go, to the point where we're now in 2014, we discovered roughly one every 3 days over the course of the year. So we're finding a lot of these cases. And there are some themes that you see in those that the Quattrone Center would then use in a root cause analysis to help to make recommendations for reform. One of the things that you see commonly is in high-profile cases where there is no physical evidence linking a defendant to the crime or the crime scene, those are much more often cases where we're seeing exonerations. And it makes sense because, number one, when you don't have physical evidence linking somebody there, then you're doing things based on circumstance and subjective assessments. And so obviously there's more risk of error there. Number two, when you have high-profile cases, particularly something that is going to be as jarring and tragic to a community as the murder of a successful and well-liked high school senior, that puts a burden on the police. And a lot of that is a very professional burden. The police in that case really want to keep those communities safe, and they really want to find the right person, and they want to do it quickly. And that pressure that's somewhat self-imposed, somewhat community-imposed, somewhat media-imposed, can often, we find, lead people to have a hypothesis for the case, seize on that hypothesis, and drive forward with that hypothesis. And we know psychologically that there's a phenomenon called cognitive bias, where you tend to accept the facts that fit your hypothesis. A good police officer doing a good investigation is going to have a hypothesis of the investigation that begins to take hold as they look at the evidence. And so it's not uncommon in that instance for facts that meet that hypothesis to be gathered in, and facts that don't agree with that hypothesis to be somewhat disregarded. And
Bad evidence. Right? That's what in the podcast, like, that's one of the detectives said, that we consider that we wouldn't look at certain things because we considered it bad evidence.
Yeah, and I think there was nothing to suggest, at least from the podcast, that those investigators were doing anything in bad faith or that they weren't doing their jobs to the best of their ability. But we know that as human beings, everybody, and particularly in these high-profile cases, you need somebody who's going to be a devil's advocate for you as the police investigator, who's blinded from the case and doesn't otherwise participate in it, so that you can test these conclusions and give them added weight. And then the other thing that we see a lot, and it's funny, I listened to the podcast while driving my kids to school in the mornings, and we would talk about a lot of these issues. And the one thing that I focused on in episode 2 or something was, I said, they're using the cell phone tower data wrong. And it made me look like a real hero with my kids, because by episode 6 or 7, when we got to that, the way that the cell phone towers work is the packets go to the closest tower, but if that tower is in use, the packets can go up to 5 towers away. So it's one of the things that we've seen is that there's a tendency to want to use cell phone towers as GPS, and they're not at all the same. GPS can put your phone within 20 feet. Cell phone towers put you within a 19 square mile radius, and that's a very, very difficult thing when you're talking about a 20-minute window, as we were in the Syed case. So we're looking at all those things in a root cause analysis to try and figure out what we really need to change to make effective improvements in the system.
Rabia, how do those concepts resonate with you, and how would you apply them to Syed's case?
I mean, they resonate very deeply with me, and I think that these, I've never practiced criminal defense law because I saw it up close and personal. As a law student during his case, I realized the potential. There's so many things that are out of your control, right? Like, you can't, whether it's from the jury to the judge to the prosecutors to investigators. I mean, as a criminal defense attorney, you're up against a lot, I realize, systematically. And then the client themselves also is at the mercy of their attorney to see, how good of a job they do. I've thought a lot about this in terms of, I feel very hopeful that Adnan is inching closer to an exoneration. We also have other things that our investigator has, found that are not publicly has not been publicly disclosed yet. But we have to obviously be a little more conclusive and be confident in some of the evidence before we move forward with it. But I think about what about the impact to the 20,000 other people who are, they say about 20,000 other people are wrongfully convicted in this country, and what that means for them, people who don't have the kind of resources that Adnan has. I mean, in many ways, he's lucky. He's got a family. He's got people who didn't forget him. He has people who still write to him and visit him, and then serial. The whole world is watching in a way. But I've been very interested in. I mean, I think the root causes have to be addressed. I think there has to be accountability measures in place, which I think helps address some of the root cause issues, because I feel like when you do have misconduct on the part of people who are part of the system, there's almost no accountability to that. And then I think of remedial things like North Carolina has an innocence commission, and I feel like that might be a way to kind of circumvent some of the systematic, like at least it doesn't help the systematic flaws, but it's a way to kind of bypass like the system basically, by giving people who say they're factually innocent another option to raise their innocence. And that's something I'm looking into in Maryland in terms of trying to establish through the legislative process an innocence commission. So, for me, it is about Adnan's case because it's deeply personal, but it certainly there are a lot of other things that I'm thinking about now, and people who support him are thinking about, and even people who are not so sure about guilt or innocence are like, things didn't work right. Still, the trial wasn't fair. So people
I think,
understand
and I think that's a big takeaway from anybody who's listened to the podcast all the way through is you may not know whether whether Adnan is guilty or innocent. And I think Sarah's sort of conclusion really kind of amounted to, in my mind, God, I really don't know if he's innocent, but I really don't believe that he's guilty. And there's a dissatisfaction with that from the perspective of somebody who's looking at the criminal justice system, that if you're going to punish somebody the way Adnan is being punished, you'd really want to be a little bit more certain than
more sure.
than that. So I think it's interesting, Robbie, to hear you talk about the North Carolina Innocence Commission. One of the things that we're doing is actually surveying that group and all of the convictions integrity units that have come up across the United States in about 20 different DA's offices, because they've all sort of sprouted up ad hoc. And North Carolina's model is unique because it's actually legislatively created and a committee that reviews these cases statewide. But Baltimore recently announced a convictions integrity unit, and I'm sure the Serial podcast, had a role in that. And it's really interesting to see the district attorney's offices now realizing that that these mistakes happen, and I think realize that there are benefits to their offices and to the communities if the offices are willing to embrace this as, look, we're not saying anybody deliberately acted wrongly here. If they did, we'll deal with that. But what we are saying is these things happen a lot more often than we want to admit, and the convictions integrity units or the innocence commissions are kind of institutional responses to that I think have a lot of promise.
Robbie, are you able to provide any insights into what Adnan's perspective is regarding the widespread attention to the case and the debate about the case?
Sure. I mean, I think, I just spoke to him a couple days ago. I'm going to see him this weekend. I have been so busy being kind of the public face for his case because he's asked me to, and his family is really not equipped to do it, that I have had much less time to actually engage to talk to him. And that's been one of the things have died down a little bit. So the next few months I'll be a lot more actively talking to him. But he I don't think there's any way for him to understand. He's in a supermax facility. He has no access to internet. He can't just make phone calls randomly. He has a very limited phone list, very limited visitation list. They get on lockdown all the time. So it's really hard for him to understand kind of the phenomena. He's never experienced social media. He knows what it is theoretically because he hears about it on TV, but he has never tweeted before, and he doesn't know what blogs are, and he doesn't. So or Reddit. He's like, I know what Reddit is, but he's never been on Reddit. He's never been on these sites. So there's no way for him to know it. And I don't personally also try to drive that home because you want to balance between, this is really good. There's a lot of scrutiny on your case now versus it's turned into a media circus and people think this is Game of Thrones, right? Like, so I don't want him to ever feel that it's become entertainment for people. Although I think it has. I mean, for some folks it has, but even that's kind of self-serving for us, I think. He gets a lot of letters. I think he's probably gotten 500 or 600 letters in the last, since Serial started. People try to send him all kinds of interesting things like cash in the mail and photographs and stuff like that. So he does understand that the response is phenomenal. What's interesting is the guards and administration at the where he's being held have listened to Serial, and they're following. So they tell him that this is what's going on, or it was on the news, or a number of guards told him, man, we always wondered why you were in here, and like, you don't belong here. We heard your story, and other inmates also they'll keep coming across newspaper articles and magazines. So he kind of gets it. His perspective really is that he's just very measured. I think he's been disappointed so many times. Like the post-conviction was supposed to be the big, like our big shot. You know, we were going to have an alibi witness presented who was never contacted. And then that alibi witness didn't show. And the prosecutor undermined the documents we had by saying that she had been coerced into writing them. And so he's hopeful, and I think he there's like a fear too, because this is kind of our last big shot. Like we're not going to get this again. It has to happen kind of like now. But at the same time, he's been disappointed a lot. So he kind of keeps me and his family in check. He says, I know everybody's excited. He's like, but you know, we have to remember there are other cases that have gotten a lot of publicity and nothing happened, you know.
So this shot turns a lot on the competency of his counsel. John, do you have any thoughts on that issue, on the competency of Adnan's defense counsel?
You know, ineffective assistance of counsel is a very difficult thing to prove. It is a sort of standard staple of the appellate practice. It's something that you throw into every case. And courts have as a result, I think, made it a fairly difficult standard. So ineffective assistance is actually, you have to show a lot of ineffectiveness. What we do see, certainly, is that there is a big disparity in the resources that the state has to investigate a case versus the resources that a typical defender, you know, whether public defender or private counsel, that any defense counsel really has to do an investigation on the other side. Certainly from what Sarah and the serial team were able to put together, it seemed like his counsel was overwhelmed, was going through a lot of things in her personal life, that things were slipping through the cracks. You know, from the recording, she seemed like a relatively capable advocate. The question is whether she was able to assemble the facts such that the jury could see them and really make a reasonable decision based on that, or whether she wasn't able to do that for a variety of factors. But it's a tough argument to make on appeal, especially when the lawyer is as experienced and has had such a long career as Adnan's attorney did.
And I'm sure you have a lot of thoughts on that, Rabia.
Yeah, and again, I'm not expressing an opinion on the actual, you know, having not seen the whole trial, having not known all the facts as well as you do, it's very difficult to really express that opinion. But it can be an uphill battle in the appellate courts.
You know, what I find fascinating is that Gutierrezz was very well known in that legal community. And her colleagues and peers saw the decline. They saw the deterioration of her performance and even her cognitive abilities and even her ability to just communicate and have a conversation in the last few years, because she was suffering from a number of illnesses that had direct impact on her ability to even communicate. And during the trial, I remember I was sitting there thinking, like, what is the point she's trying to make? She would ask the same question repetitively, and there were times when the witness would be like, I don't even know what you're asking. So you could see that she was just struggling, but she was just going on. And the reason the state's case lasted that long, because on cross she would take forever and ever and ever, and there were many times the judge said, listen, how much longer do you need? So she wasn't what an attorney should be, which is tight, precise, you know, and this I think was directly related to her illness. At the same time, I can't attribute everything to her illness, because there were things she did that were clearly unethical. Like, for example, say, I need you to write me a check specifically for a purpose, and then not fulfill that purpose. I mean, we heard in the podcast, you know, what she did with the Whitmans, where there are times that she clearly just lied. We know towards the end of the end of her career, she was just not competent anymore. I mean, 28 different cases and clients complaining against her, and emptied out the Attorney Grievance Commission's fund, should show us that that was not the Gutierrezz who was in her heyday. But you know, the community's tight. I've had some people reach out to me who worked with her at the time, not attorneys, but paralegals and law clerks, and they're willing to go on the record and say, yeah, we saw this happen. We knew things were really bad. She had financial issues, medical issues. She was really struggling, and she was just really being, you know, she was not doing what she needed to do as an attorney for her clients. But for the lawyers who worked with her, they've kind of been quiet about it, you know. And I think it's out of deference and respect for her. But at the same time, if you have 28 different cases, you know, like, they have to be looked at, you know, like, did these people get competent counsel or not? So you can't give a pass to that. You can even say, you know, you don't have to say it was on purpose if people are uncomfortable saying that she acted unethically on purpose. But even if she was medically incompetent, right? Like, I mean, if she just didn't have the cognitive ability, that should be a reason to say that, she was ineffective. And but we have the ineffective assistance issues. There are other issues that our attorney did not raise at post conviction, and if we were to go to another post conviction, we would raise. And that, for example, we haven't even touched on it here, is how bigoted the trial was. We had this entire framing of he's a young Muslim man who committed an honor killing. The word Islam, Muslim, or Pakistan was brought up 270 times during the trial. Instead of moving to strike every time that came up, and because it's unconstitutional to do this, Gutierrezs would, in fact, she would exacerbate the problem by talking about Islam for like 40 minutes at a time, at a stretch. I remember her examining a witness and talking to him about, how do you pray? Do you pray with your hands folded? And I'm like, what? Why is this a component in this trial? Our community was horrified. We couldn't believe that this was happening. Adnan, who's like a very American boy, on one hand, you're like, okay, he's drinking and smoking pot and dating, and then you're gonna leap to the conclusion he doesn't have any violent history, no criminal record. Because he's a Muslim male, that kind of stands in for that. He's already predisposed as a Muslim male. And that's an issue that has never been addressed in court. That this was incredibly bigoted and unconstitutional to do that. The South Asian Bar Association, the National South Asian Bar Association, was so disturbed by this when they heard the podcast, and I turned over the transcripts to them. They wanted to file an amicus, in support and point out other cases where references to a person's ethnicity or they've been overturned, but it procedurally just didn't work. So we are right now limited to the IAC issues and effective assistance, but there are other issues that certainly could be raised if we had to.
And to follow up on that with you, John, what are your thoughts on the prosecutor's evidence and the defense's disputes with that?
Well, I think that in any case, there is evidence that both sides will have that they don't choose to bring to trial for one reason or another. It may be because they don't think the evidence is accurate. It may be because they make strategic decisions about what's going to advance their case. Obviously, prosecutors have an obligation to turn over evidence that might tend to prove the innocence of the person that they've charged. And it's the burden of the prosecutors then they have the burden of proof. They're the people who have to show guilt beyond a reasonable doubt, even after providing that information to the defense. So I think if you were going to review the case, you'd want to make sure that that had happened, that all of the evidence that was, and the prosecutor's obligation is to turn over any evidence anywhere in the state. So it's not just what the prosecutor has, but it's any police or investigational body as well. And their obligation is to collect all that and provide anything that might show evidence that Adnan in this case might be innocent. So the first thing you'd want to do is evaluate whether all of that had been done. But typically courts give a lot of leeway to attorneys in making those strategic decisions based on the facts of each case. And that's part of the challenge with an ineffective assistance claim, is that when you look at some of the decisions that either the prosecutors or the defense made, the question is, are they within the rules of evidence, and were they made for strategic purposes? Because in general, an appeals court doesn't want to get in the lawyer's head and control those decisions. So I think those are the things that you'd want to look at in understanding that. Hopefully, you'd like to think that some of the ethnic issues that Rabia raises are not in the jury's minds. We do have, in theory, some techniques for handling that. That should be something that we try to pick up in voir dire while we're choosing the jury. And then jury polling can also, I think, maybe get at that question in some sense after the fact. And I haven't reviewed either of those or know if jury polling was done in this case, but you'd certainly hate to think that was a factor.
Well, Sarah did speak to a couple of the jurors during the podcast, and they said, well, yeah, that kind of, they kind of treat their women like that. So, in a case like this, voir dire would not have worked, because you had selected a jury that, on the face of it, it seems to have no bias, but then in the entire case, they're like pounded with these stereotypes of Muslims in general, and it's all based on this ridiculous memo that was in the police files, that it was some kind of cultural memo on Islam, like Islam is a culture to begin with, and the whole memo was inaccurate, the whole memo was inflammatory. The memo is on my blog, and we didn't have a copy of that. No, defense didn't have a copy of that. I don't know why the police had that. We don't know why the prosecution had that. who provided it, who solicited it. We have none of that information. It just exists there. And that was like the basis of their, like the theory of the case. They focused on Adnan before Jay Wiles came to them. They focused on Adnan over Hayes' current boyfriend, who she had been dating shortly, who had been with her the night before, had spoken to her until 3 a.m., who likewise, like Adnan, said, I never called her again after that. He had been with her the night before, and he never reached out to check with her, whose alibi for that day was his mother. There was no reason to focus on Adnan versus him other than the fact that Adnan was a young Muslim man. And that I stand by that. I believe that because this memo to me shows that this is what they built their case on, and the jury heard it for 6 weeks, So they might not have come in thinking they have any bias, but after 6 weeks of hearing it, you don't know that community. And our community, the optics of the community are you have Adnan who just looks like an average teenager, but then you have rows of people who look very foreign. You have women in their scarves and you have men with beards. And this is before 9/11, but it doesn't mean that there wasn't any bias. There was still bias against Muslims and not knowing who this community is. And the prosecution, it was all about that. He was denied bail for this reason. That, this community that has come out in droves, that have put up their houses, as to guarantee that he'll appear in court, that are giving all kinds of, you have doctors and all kinds of people in that room. The prosecution turns around and said, see, though, this community, these are the people who are going to help him escape. Because in their culture, it's okay to hurt a young woman if she besmirches your honor, So I'm sorry, I get a little bit carried away on this issue, and I feel like so far none of Adnan's attorneys, maybe because they don't understand what this really means for somebody who's South Asian or immigrant or this idea that he's living this double life, which is so ridiculous. If it hasn't ever impacted you, you don't understand what it really means. So.
Well, in a sense, what you would hope is that the system kind of puts Adnan's race or Hayes' race or anybody's race aside and is looking at the facts of what happened and trying to establish the guilt. Because the fact of the matter is, whether you're white, black, Muslim, Asian, whatever you are, your race has no bearing on whether or not you actually murdered somebody or didn't. And so I think it's wholly appropriate that we hold our system up to that light, that we hold it accountable for acting in a race-free manner. I'm not sure that you can say from the fact that somebody who was accused of a brutal murder was held without bail that you can necessarily draw a line directly from that to the person's race. You would certainly want to look at that person's background and a whole host of other factors, but at the end of the day, if you have enough to charge somebody with a brutal murder, you want to keep that person off the streets while you're figuring out what really happened. And so that's certainly a very common way to go, but I do think it's important that we look at the facts of this case and try to make sure that we weren't using a racial filter to do that.
I wish the prosecution had looked at the facts, I mean, the judge in the bail hearing, I understand that in most cases like this, they deny bail. But it's not about why the judge made that decision. It's about how the state framed the case. And that is how the state framed his motive. It was all tied to his religion and his ethnic background.
Robbie, what are your thoughts on advocating through the media and Serial? And do you feel that it's helped Syed?
Oh, absolutely. I mean, look, a year ago, we had this application pending. We knew that there was almost no chance at all that it was going to be granted. We didn't think we'd get another shot at post-conviction. So, my role in this has been, and I told Sarah when the podcast started, because I didn't even know it was going to be like a series. I had never heard a podcast before. But as, within the first couple of weeks, when I realized, the popularity and the immediate public response, I realized that Sarah is telling part of the story, but it's not the whole story. And I have documents and I have other things that could fill in the gaps. And I just decided that I have to do that. I started blogging and speaking and doing videos online and all this stuff because I knew we had one chance. Because when Serial's over, people are going to look forward to the next season of Serial. They're going to forget Adnan Syed. That's how people work. And I couldn't let that happen. So it's been tremendously successful for us in terms of fundraising. We've raised close to $100,000 for his defense to hire a private investigator to do things right this time. We have a petition with over 30,000 signatures. We have, people independently doing fundraisers and selling T-shirts for him, no connection to us at all. And we have everybody kind of keeping an eye on the case and seeing what happens. When Adnan's this appeal was granted, it appeared on the front page of BBC, and it's like a Baltimore case. It's just ridiculous that a state level case, a homicide case, that it would have that much attention. So it's worked for us. I have to say, it's worked for us. but also because, we're in a situation where all disclosure can just help. More and more information can only help us. That's how I feel, because I feel he's innocent. So there's no necessary fear that something will emerge that could hurt us. So it's been good for us.
You just mentioned, and as a final question for both of you, the enormous interest that Serial Podcast has generated. For this particular case and cases like it, what advice do you have for law students who seek to work in this field, and members of the general public as well?
I mean, again, I have absolutely no experience practicing criminal defense law. So, but my work as an attorney has always been directly impacted by witnessing, like, what happened in this case, up close and personal. I mean, my advice, I'm sure that John has better advice. I mean, he understands the systematic issues much better than I do, and he probably could offer better advice. But my advice is that to me, when you have a duty, whether you're on any side of these issues, whether you're an investigator, a prosecutor, a judge, a jury, I mean, like, that you have to understand that this is a person's entire life, in your hands. And oftentimes, like somebody like Adnan, who's sitting there at 17, he has absolutely no voice. He's entrusted his entire life to this attorney, and to all these adults who are going to produce some result and make a decision of how the rest of his life is going to be led. And this is a major, major, I consider it like a trust, like you've been entrusted with something really important, and to take it that seriously, and not, meeting a duty, like, should not be your bar. Your bar should not be just getting by. Your bar should be, what's the most I can do to make sure that we are getting this right. And so, that's, I guess, the only advice I could offer students, is that don't take more than you can handle, quality over quantity, and do the best that you can for your clients and for whatever institutions you're working for. Take it very seriously, because the repercussions are not, it's to the families, it's to the communities, and it goes on for years and years.
Great. Advice from you, John?
Well, I mean, that's fantastic advice, and something that I think every lawyer at any level should be keeping front of mind all the time. The obligation that we have as citizens, whatever our role is in our interaction with the criminal justice system, is that we have to make sure we've set up a system that is designed to only incarcerate people if we are certain that they have committed a crime, right? Beyond a reasonable doubt that this person has committed a crime. I wrote a book about a man who was tried and convicted of murder, and 18 years later retried and exonerated of that murder. And it struck me as really interesting that two different juries had heard his case, and one of them was certain that he was guilty, and the other was certain that he was innocent. And it shows you the power that the attorneys and the judges and the juries have to impact somebody's life. And that the presentation of facts, the selective presentation of facts that we manage in the criminal justice system, can have an impact on the result, but it doesn't change what happened. What happened is what happened. What changes now is how we perceive what happened because of how that system has worked. And that puts a burden on all of us. But one of the people that it puts a burden on is, when I hear somebody on the radio say that somebody's now been arrested of a crime, I think of that very differently. Before I thought, oh, they wouldn't have arrested him if he hadn't done it. And now I think, well, anybody can get arrested, right? That doesn't mean that he committed the crime. That means that now we really have to test those theories. So I think as citizens, what we have to do is be very serious about making sure that we are testing that and not simply agreeing with the state. Doesn't mean the state's wrong, but we have to hold them to that burden of proof. The other thing that I think as lawyers is it's very important. I call it the show your work rule, right? When you were in 7th grade and you were in math class and you'd only get half credit if you got the answer right, but you didn't show your work. It's really important to have somebody look at your work and check your math. And you need to, as a lawyer, whether you're on the defense side, whether you're on the prosecution side, whether you're working with law enforcement, there needs to be somebody independent from your case that you take it to and say, I think this is what we've got. What are the holes here? What are the weaknesses? What do you see? Do you agree? And that person needs to be an independent reviewer who can check your work, because that's the single biggest thing that we see at any point in the system that will eliminate errors leading to wrongful convictions.
Well, thanks very much to both of you, and thanks for joining us in Case in Point.
Thanks.
Thank you.
And thank you, Robbie, for the work you're doing.
Thank you, John.